everyone, this is the last word. Allahabad High Court's insensitive ruling on rape has been slammed by members of the legal fraternity and also the lawmakers. Union Minister for Women and Child Development, Annpurna Devi, today said that the Supreme Court should intervene in the Allahabad High Court's ruling. The Allahabad High Court on March 17th had said that actions like grabbing breasts or snapping a pyjama string do not constitute rape or an attempt to rape, but rather fall under the lesser charge of aggravated sexual assault. A bench of Justice Ram Manohar Narayanan Mishra stated that there was a gap between preparation for a crime and an actual attempt to commit a crime. The judge, in fact, concluded that the case did not meet the legal threshold for an attempt to commit rape. The court further remarked, and I quote, "The difference between preparation and actual attempt to commit an offence consists chiefly in the greater degree of determination." The Supreme Court will hear the matter now on 24th of March after a PIL was moved seeking to expunge the controversial part and wrong interpretation of the statute. First up, all the reactions that came on the story today, and then I bring in the guests.
जो टिप्पणी अभी इलाहाबाद हाई कोर्ट की ओर से की गई है, हमें लगता है कि इस तरह की टिप्पणी कहीं भी शोभा नहीं देती। मतलब और इसके वजह से चूंकि बहुत सारे ऐसे डिसीजन हुए हैं, उस पर भी प्रभाव पड़ेगा और इससे गलत करने के लिए लोगों की और मानसिकताएं बढ़ेंगी।
एक बच्ची के साथ इतना गलत हुआ और उसके बाद इलाहाबाद हाई कोर्ट के जज ये कह रहे हैं कि ऐसा लगता नहीं है कि उसकी रेप करने की कोशिश की गई है। मुझे इस स्टेटमेंट में कोई लॉजिक समझ नहीं आ रहा। मुझे लगता है कि ये स्टेटमेंट बहुत ज़्यादा इनसेंसिटिव है और मेरा ऐसा मानना है कि ये समाज के लिए काफ़ी खतरनाक है और मैं चाहती हूँ कि ऑनरेबल सुप्रीम कोर्ट इस मामले में इंटरवीन करे।
I can't really comment on a judgment because it comes straight from the High Court, and it's high time that we get our people start taking women seriously, and it's quite disgusting. There's a complete disregard of women by and large in the country, which we need to get over with.
The reports which have appeared in the public space, if they are correct, then obviously it's a very serious matter. Going by the reports, the Supreme Court Collegium seems to have taken cognizance of the matter. So therefore, let's wait and see as to what the Supreme Court Collegium finally decides with regard to this matter.
And joining me now is Justice Usha Mehra, former judge of the Delhi High Court. We also have Yashwardhan Azad, former IPS officer. Jagmati Sangwan is a woman activist. We'll also be joined by the petitioner in this case, Advocate Anjali Patel, in just a bit. Justice Mehra, I want to understand from you. I mean, many would say that this is an interpretation of the POCSO Act, but the problem here is also that there is this misinterpretation which is happening of the actual act.
Yes, sir. As a matter of fact, it is a very serious matter.
Yes.
And Supreme Court has repeatedly said in a POCSO matter, you have not to see that it is a penetration only, then it is a rape. In such a matter, touching the girl, a small child, at different places which are objectionable will amount to rape. If this judgment continue, I am very sure it will have a very adverse effect in the trial of other POCSO cases. And to my mind, the Supreme Court should suo motu entertain the appeal and take action against such a judgment.
Do you think that this judgment actually reflects a legal loophole, or is it a misinterpretation of existing laws on sexual assault? And should the definition of rape then be expanded?
It's a misinterpretation, and even if the judgment ignores the Supreme Court views given in various judgments, when the Supreme Court has said touching a girl who is less than 18 years at a wrong places will amount to intention to rape.
Okay.
This judgment ignores those judgments of the Supreme Court and has wrongly interpreted that is only when intercourse takes place or insertion has been done, only then it amounts to rape, which is not the intention of the act.
Okay. And in this particular case, Yashvardhan Azad, the court modified the charges against the two accused from section 376 IPC, which is rape, to another section, which is essentially assault. Do you think that this lesser charge would essentially mean that it's lesser punishment?
Absolutely, and it's really unfair. As Justice Mehra has laid it out very, very clearly, you know, we didn't need Supreme Court even to say this, but if Supreme Court has even said that the rape does not really mean the actual penetration, but any act leading towards it, you know, and the mens rea or the intention is very, very clear that the women or the girls are being dragged somewhere after their, you know, parts being touched and things like that. I'm shocked. This is like a kind of an opinion expressed by somebody and not really a judgment. And that's why I would feel that this is a very, very retrograde step. You know, whatever we have been trying to do from Justice Verma's commission to till now, and having a new set of laws giving primacy to the assault against women, if this is the kind of a judgment we received, I'm really not very hopeful that we'll go very far. And that's why it is critical that the Supreme Court should hear this immediately and take corrective steps.
You know, because there is, you know, because I've been reading a lot of anguish which has been shared, and Anjali Patel, who's the petitioner, is also joining us. Anjali, the point here is that Section 376 IPC, which reads with Section 18 of the POCSO Act, if there is an attempt to dilute POCSO Act with this kind of judgment, is it also not challenging what the Supreme Court has said very clearly, that it's not just about penetration, rape is about even that inappropriate touching?
सबसे पहले मेरा नमस्कार मेरे दर्शकों को और मेरे साथ में जो जुड़े हुए हैं उनको। सबसे पहले मैं आपको बताना चाहूँगी कि मैंने जैसे ही इस न्यूज़ को देखा और मैं एज अ एडवोकेट इस न्यूज़ को देखते ही मुझे ये लगा कि मुझे इसको किस तरीके से शो हुआ, और एज अ फीमेल मुझे बहुत ही ज़्यादा निगेटिव फील हुआ कि इस तरीके से अनेबल जजेस जो हायर जुडिशरी में हैं और हायर जुडिशरी में होके जो इस तरीके का काम कर रहे हैं, एक अच्छे तरीके से काम करने के बजाय इस तरीके से महिलाओं के लिए फीमेल की डिग्निटी को ना केयर करते हुए इस तरीके का आर्डर पास कर रहे हैं, जो सबसे ज़्यादा ही अभद्र तरीके का लैंग्वेज है। और इस पर मैं चाहती हूँ कि एटलीस्ट सुप्रीम कोर्ट, मैंने जो याचिका दाखिल की है जिसमें मैंने 2 प्रेयर किए हैं, और मेरी पहली प्रेयर यही है कि सबसे पहले जो पैरा 26 है उसको रिमूव किया जाए, एक्सपंज किया जाए जल्दी से जल्दी। और दूसरी प्रेयर ये है कि इस तरीके से जो कमेंट पास हो रहे हैं, और सुप्रीम कोर्ट इस पर बार बार कह रहे हैं कि इस तरीके के कमेंट्स नहीं होना चाहिए। रिसेंटली जस्टिस जो अनेवल सूर्यकांत जस्टिस हैं, उन्होंने भी कहा कि इस तरीके की अभद्र लैंग्वेज का यूज ना किया जाए और इस तरीके वल्गर लैंग्वेज ना आए सामने, लेकिन किसी भी तरीके का ये लैंग्वेज फिनिश ही नहीं हो रहा है। और हायर जुडिशरी लास्टली कर्नाटका हाई कोर्ट में भी इस तरीके का हुआ था और उस पर अनेवल सुप्रीम कोर्ट ने सो मोटो लिया था।
Yes. Jagmati, there is a counter argument in this entire case as well, which says that, you know, there is a need to distinguish between sexual assault and attempt to rape, because then it actually is about reasoned application of mind, as has been mandated by the Supreme Court in the Sunil Bharti Mittal versus CBI case of 2015.
No, there is an attempt to rape is very clear from the facts of this case. He grabbed the breast, then he tried to open the string of her pant, whatever she was wearing. Is it not an attempt? What else it is?
Yes. Jagmati, the question was for you. Since you work with, you know, you're an activist, you understand how difficult it is for women and minors to, in general, get justice.
Yes, Maria, we strongly condemn the judgment. It is against the spirit of safety, security concerns of women, and at the same time against the constitutional spirit. And at the same time, I want to say that such utterances by the judge himself are needed to be looked into in a specific context. Where the laws already enacted for the safety security of women are being उनको ढीला किया जा रहा है, उनकी आत्मा को मारा जा रहा है, और एक तरह से तमाम तरह के पूर्वाग्रह जो है वो उनके खिलाफ काम करते नजर आ रहे हैं। जज को क्या पता नहीं लग रहा कि लड़की को पुल के नीचे क्यों खींच के ले जा रहे हैं, और अगर लोग जो राहगीर वहां पे आ रहे थे वो अगर नहीं बोलते और नहीं देखते इन नजरों से कि क्या किया जा रहा है, तो ये सामने भी नहीं आने देना था। ये पूरा केस जो है, ऐसे हालात बने हुए हैं देश के अंदर। ये जो कॉन्टेक्स्ट है पूरा, इसमें ये इस तरह के जो जजेस के द्वारा जो टिप्पणियां हैं, these comments of the judges, these are really harmful to the safety security of women in this country, and we strongly demand from the Supreme Court that they should take the suo motu cognizance on this particular issue, and because it is totally against the recommendations of Justice Verma Committee, which came out after a huge lot of efforts by the citizens of this country who want their daughters and their females to be a proud citizens of this country, and they should not be victimized by such criminals. And here in this judgment, it seems the judge has tried to show his creativity to its limit to defend the criminals. He is not at all looking the trauma this girl has gone through, and the other girls, just now Anjali pointed out how she felt when she heard of this judgment, and how the females of this country feel about such judges.
Ma'am. Besides feeling bad and all, let's get into besides, the larger question is it's about the application of a mind, and there is misinterpretation which has happened. But what can be done is the larger question here. And Justice Mehra, perhaps you'll be able to explain things to us better as to
I
why.
I want to make one point.
I'm coming back to you. I'm coming back to you. Please hold on to your thoughts. Because, the modification of charges in the POCSO Act has happened in this particular case. Even if there is a review or a PIL which has been filed already in the Supreme Court, it will be taken up next week. What can be done? Do you think the entire order can be expunged, or do you think it will be just about these specific paragraphs? But the larger point is also, ma'am, that the entire modification has meant dilution of charges.
Not only the modification, the Supreme Court will have to set aside such a judgment,
yes,
and ask for the appeal to be reheard by another judge. It has to be set aside.
Okay.
In totality.
Where do you think the problem lies here?
Supreme Court cannot say you modified this charge or distinguish this charge. That can be done by the trial court. Now the trial court has already taken some view which the High Court judge has not endorsed. Under these circumstances, it is for the Supreme Court to set aside the complete judgment, and then whatever appeal is should be listed before some other judge to be reheard.
And what happens to those who interpret these judgments and those who write these judgments, Yashwardhan Azad? Because the Allahabad High Court is unfortunately delivering way too controversial judgments in recent months and years.
No, I totally agree with you. In fact, this is also contextual. For example, if this same action would have taken place in a college, by a college boy against a girl where there are so many people around, it can constitute a sexual assault. But it is happening in a different context, and as pointed out by Jagmati ji and other people, that it happened in a particular secluded place. I mean, common sense tells you that it is an attempt to rape. So I'm really shocked about this. So I think the Supreme Court, if it does not reassert its guidelines by setting this judgment aside, we are in a very bad situation, and this should not be allowed anymore. Especially Allahabad High Court judges have been giving many controversial judgments. It's up to the Supreme Court. In fact, I don't want to refer to it, but the cash pile recovered at a particular place, it's a disgraceful act for which he's been given a graceful exit by mere transfer. And that also to Allahabad High Court back. That's another point here for you.
I get your larger point. Perhaps I'm going to take that up on the big fight in just a few minutes. But Yashwardhan Azad, many say that judges are you don't judge the judges. And an interpretation of this nature, from where does it actually come? Technicalities, or is this application of mind? What exactly makes one come up with a judgment which is completely, not really factual?
Maria, there are many judgments. For example, when I was in the Central Information Commission, there were many of these judgments who we were a little bewildered with, but we thought it's an individual judge's belief on a particular issue. But if the issue is of such a large nature, which almost impacts half the mankind, 49% are women, then obviously it's going to rake up controversy. It's going to rake up a right amount of resentment against these kind of judicial opinions or verdicts. And that's why it's extremely important for the Supreme Court to set in and reassert its supremacy. That is why it's important. In many of the judgments, we may not agree, but fine, it is an individual kind of an opinion which is expressed. Though I'll still say that a lot of individual opinions are being expressed which was not necessary at all by the High Court judges. But on an issue of this kind, if it's expressed like this, there is certainly going to be a lot of resentment, and Supreme Court must step in.
Okay, one point which was made, and I'm going to bring in Justice Mehra again. Justice Mehra, the court emphasized that for an attempt to rape to be established, the prosecution must prove a great degree of determination beyond mere preparation. And then there are historical precedents which have been cited, which includes Express versus Shankar 1881. It noted that the absence of any allegation of penetrative assault or further acts to consummate rape undermine the charge of attempt.
The judgment he has cited is of 1981. It's not after the amendment of the...
that's the point. Yes, please go ahead.
Criminal Procedure Code. So when the Criminal Procedure Code has been amended, and the amendment has brought all these provisions on the statute book, saying that any attempt which tantamounts to rape will be a rape. And in this case, the facts which are on record, that he touched her, he didn't only touch, he tried to crush her breast, he took her to a lonely place, he unstinged her pyjama, and he was going to rape unless some people gathered there and saved the child. So therefore, the intention is clear that he wanted to do the rape. That is sufficient under the present Criminal Procedure Code, and hence the punishment should have been given. The mindset of the judge appears to be that touching a woman skin to skin, coming near to her, touching her private parts is not a rape, shows the mind of the judge, but not the law. It's a personal view of the judge and not a legal interpretation of the law.
Yes, because the legal interpretation should have taken into account the changes which have happened in the CRPC, which has not happened in this particular case. Correct me, Justice Mehra.
Yes, it is because he has not taken into account the amended criminal procedure. He has not bothered to go into the facts of the case. According to him, removing girl inner wear doesn't make much difference by the man. whose intention was to rape her. Otherwise, why would he take her, as have been told by one of the panelists, to a lonely place? To do what? To laugh with her? Or to give food to her? What? The very fact he took her to a lonely place, the very fact that he tried to unrobe her and tried to touch her private parts shows his intention. And intention clearly is inferred from the facts of the case.
So I'll give 30 seconds to both Jagmati and Anjali. Jagmati, coming to you. Please go ahead. You wanted to make a point.
Yes, Maria, being responsible citizen of the country, we want to judge our judges. They don't have absolute power. They have taken oath to defend the Constitution of India and the dignity of women of this country, and they should be held accountable. They can't pass such judgments and go free. No. They would have to reply to the citizens of this country, and at the same time the Supreme Court should fix up such judges. In earlier cases also, the Allahabad High Court judges are coming out with objectionable comments. Earlier also, one judge, while he was participating in a VHP program, and the comments he made. In this particular context the country is passing through, the Supreme Court need to be much more alert about defending the rights of deprived sections of this country. That is what I want to say.
Okay. Anjali?
Yes. मैम मेरा जो मैं कहने वाली थी मैम ने बोल ही दिया, लेकिन लास्ट ये है कि एटलीस्ट इस याचिका को अनेबल सुप्रीम कोर्ट मंडे में सुनने के लिए में भी रेडी हैं अनेबल जजेस, और उसमें मेरा बस यही रहेगा कि इस याचिका पे जो 2 प्रेयर मैंने किए हैं उनको फॉलो किया जाए। और हमारी एक चीज और कहना चाहूंगी, जो हमारे देश में कहा जाता है ना कि बेटी बचाओ बेटी पढ़ाओ, क्या अब मैं ये जानना चाहती हूँ क्या ये अनेबल जजेस क्या अशिक्षित थे जिन्होंने इस तरीके की लैंग्वेज और अभद्र लैंग्वेज का यूज किया और इतना महिलाओं की डिग्निटी जो है इस तरीके से की है कि कुछ कहा नहीं जा सकता इस कमेंट्स के लिए। तो बस मेरा आप आगे।
It's a deeply disturbing judgment for sure. But because a PIL has been filed, it will be taken up. And as Justice Mehra said, it has to be struck down completely or set aside so that it doesn't really become a precedent. Thank you so much for joining us, Justice Mehra. Pleasure having you on my show. Yashwardhan Azad, Jagmati and Anjali Patel.